Hello class, this is Dr. Fenton. In this video, we're going to talk about a new area in forensic accounting called litigation support. Now in the previous chapters we talked about fraud examination, we looked at that in detail, but now we get into a new area, and I think this new area, litigation support is a very interesting area that would be a great career for a forensic accountant. Let's get started. Lower my window. There we go, Chapter 8. Again, litigation services provided by accountants. So the next page. Wanted to show you this this little cartoon here, and you don't want to be in this situation. So here it looks like an accountant and talking on the phone. It says, "I know nothing about the subject, but I'm happy to give you my expert opinion." You do not want to do this. If you're going to give an opinion, you'd better be an expert in that area, know everything about that area. So just be careful with your work. Now, tort. Hopefully you know what tort is. That tort is where one party injures another one, usually not physically, but injures another one, and there's harm involved. So it usually might be some kind of monetary compensation that's being sought. It could be one business damaged another business in some form or fashion. So tort is usually handled at the civil litigation area as opposed to the criminal litigation area. Look at what I've highlighted here. U.S. torts were close to $429 billion in 2017. Those are the losses in tort court cases. So it's big money. These cases are going on all the time. And the thing about it, when you have a court case, of course you have the plaintiff and the defendant. If dollars are involved, probably both sides have accountants working for them. And these are what the forensic accountants will do. Become expert witnesses. We'll come up with estimated loss numbers. So this is a big area, and as I said before, I think a very interesting area. So make sure you read through this yourself. Now when we look at this one, let's see, down here, a dispute begins. Now, we talked about civil and criminal. Of course, big differences here. Now, if you're involved in a civil trial, if there's a civil trial, the burden of proof for like guilty is lower than a criminal trial, much lower, much lower. And what it says here in the second highlight is that it's a preponderance of evidence, more than 50%. Whereas the criminal, you're up there, some people are saying like 95% certainty or more, but on the civil area it could be as low as 51%. Let's scroll down a little bit. Now I want you to make sure you know these. These are the 6 major phases of litigation. You have the pleadings, discovery, pretrial conferences, trial, if you go that far. In the pretrial conferences you might try to settle out of court, the outcome, and the possible appeal. Now much of the work that forensic accountants will perform will be in the discovery stage. If it is a business situation where one business is suing another one, you have all kinds of accounting records, tax returns to go through, either to request or so forth, other business records, maybe loan documents, and so the discovery is where a lot of work will happen for the forensic accountant. Now they will be involved in maybe some of these later stages. If the case makes it to trial, the forensic accountant as an expert witness will probably be on the witness stand to explain his or her report. This says that an attorney's job is to ultimately avoid trial and the resulting lost time and expenses. In other words, you want to settle. So hopefully you can build a good enough case for your side, whether you're the plaintiff or the defendant, to make the other side see, it's better to go ahead and settle before we go to trial. Because you get to trial, you never know which way it's going to work out. So it's the accountant's, the forensic accountant's duty to help that attorney get to the point where maybe it'll settle before it goes to the full trial. Talked about the pretrial conferences, again, to encourage settlement. And then on the green part here, usually a person has the right to a jury trial. That's in the district courts. The jurors can only determine the facts of the case, not the law. then there's an automatic appeal to the next higher level court, to the appellate court. That's automatic. After the appellate court, it's not automatic usually, at least not in the federal court system, because the Supreme Court will look at the appeal to the Supreme Court and they can either accept it or reject it. Okay? If they accept it, they'll issue what's called a writ of certiorari. That means they will accept the case into the Supreme Court. So you have your right at the trial court, jury if you want it. If you lose at the trial court level, you can appeal. You're guaranteed an appellate court will hear your case. After that, Supreme Court might not happen. They get to pick and choose which cases they hear. Now, what kind of witnesses are there in the court system? They have various here. We have the fact or lay witness. They're just witnessing to facts. Here is exactly what happened. The expert witness, that's where you come in as a forensic accountant, as an expert witness. You will say, I looked at the facts, and here's my opinion on what the damages were. Not opinion on, is that person innocent or guilty? That's not for the forensic accountant to decide whatsoever. No. The expert witness will issue a report that has an opinion. In my opinion, I believe here is the amount of the loss. Next kind of witness is a summary witness, and then special masters. Now, this area right in here talks about what an expert is, and so you have specialized knowledge. You have that background. You have that education. You have that certification, and that sets you apart as an expert witness. And there you can give your opinion. I'd like for you to read the other pages here that talk about the other kinds of experts. Let's go to the next page. Now, consultant. This is an interesting option. If you are interested in this area, but you're not ready to put yourself out there as an expert witness, you don't want to have to testify at the deposition or in the courtroom, but you want to do some work on court cases, maybe an attorney will hire you to review records, to maybe make some computations, but you're working behind the scenes. You will never express an opinion. You're just helping the attorney behind the scenes. That's different than being an expert witness. That's the next part down here. The expert witness, you will do a lot of work. You will review documents. You'll review other person's depositions. You'll come up with your own opinion as to damages. Use it for the accountants, the amount of the damages. You'll give that opinion. You'll have a written report. You're the expert. You can give your opinion on this. And you're out there. I mean, people will know, the other side will know you're the expert. You'll be deposed, and you might end up on the witness stand in trial. So there's a big difference between a consultant. You work behind the scenes, completely under the umbrella of the attorney. With the expert witness, yes, you're still working for the attorney, but your work's going to be out there with your opinion, and you have to defend it. So they're completely different, the consultant and expert witness. I'd like for you to read about the masters and special masters. This is work you can get involved in where a judge needs help to maybe go through a lot of material, and then you report back to the court. You're working for the court, for the judge, not for one party or the other. Read through this, of course, and we have some, AICPA, of course, that's the American Institute of Certified Public Accountants, and they say here are some rules that are relevant to litigation services. So professional competence, of course. Independence. You must be independent. For the party you're working for, you must have an independent attitude and be viewed as independent. So you cannot be a relative or things like that. Objectivity and integrity. That's a must-have. If the judge or jury is to believe you, you must appear objective and have integrity. Confidential information. Like most areas in accounting, you cannot, talk about what you're doing in detail with other people just off the street. So confidential, yes. Conflicts of interest. You cannot have this. Again, it can be maybe other lawsuits you're involved in, somehow involved with one of the other parties. Again, your relatives come in here. You cannot really represent a relative. to be a objective expert witness. So you cannot have any conflicts of interest. We'll talk about more down here. You cannot have any relationships that might lead others to think would impair their integrity and objectivity in performing the litigation services. So you must be completely objective. Now the next page. This is very important. Very, very important. If you agree to work as an expert witness on a court case for an attorney, and remember, if you're doing this work, your client is the attorney, either the plaintiff's attorney or the defendant's attorney. Your client is not the plaintiff or the defendant. You're working for the attorney. You need to have an engagement letter. This is the written agreement, an engagement letter that specifies a lot of information. You want to make sure that attorney you're working for understands exactly what your services will be and which case you're going to work on, the nature of litigations, whether or not you'll be asked to testify as an expert witness. That could be possible. Any restrictions on your work, and you can see the others, even your fee, of course. Now I have a little button over here. I don't know if you can see it, but I'm going to pop this out. There is a sample engagement letter, really two of them, in your textbook in Appendix 1. They are very good. The second letter, I'm going to glance at it in my book real quick. The first letter is just 1 page long. The second letter is, yes, 2.5 pages long, an engagement letter. So you're telling the attorney, here is my agreement between you and me. So these are very, very important to put this in writing and make sure everyone understands exactly what work you're going to do. Now, what do lawyers look for in an expert witness? Remember, you're the forensic accountant, the expert witness. You're working for the attorney, right? What will they be looking for? Here's a whole list of items. Okay, I'll let you read through these yourself, but again, you have to be focused. You have to be respected in the community, in your professional community. They think the attorney thinks you'll be likable to the jurors, and next to the last one says, good teachers, because you're going to be explaining things to people who are not accounting experts. So you have to be able to explain it very clearly. Okay? So this is what attorneys look for. And once you do your work, you're identified as an expert, you have your report, then the other side of the court case, they're going to be coming after you. They might try to get you kicked off the case. They will try to challenge you. And this Dahlberg, some people call this Dahlberg. I've heard that a little bit. Most people, I think, call it Dahlberg, and it's a Dahlberg challenge. We'll look at the court case in just a second. The Dahlberg challenge is to go after the other person's expert witness. So if you're hit with a Dahlberg challenge, the other side is trying to show that you're not qualified, either not qualified or your work is so poor or something. They're trying to kick you and your work off the case. You don't want that to happen. You don't want to fail a Dahlberg challenge, okay? And so they'll look at a lot of these things. Let's go to the Dahlberg case right here. Now the Dahlberg case is Dahlberg versus Meridau Pharmaceuticals. This is where the Supreme Court established the rule for federal courts that trial judges have a special responsibility to ensure that scientific testimony is not only relevant but also reliable. And then a later case, the Kumho Tire Company case, and the Supreme Court said that a gatekeeping obligation applies not only to the scientific testimony but to all expert testimony. So these Dahlberg rules you have to fall under, right? And the other side will try to challenge you to try to get you kicked off the case. Now, a simple Dahlberg challenge is here. There's a motion in limine, that's the Dahlberg challenge. And then the other party wants a summary judgment to kick you off the case. Both sides file documents. There are hearings then in front of the judge and lawyers, and the judge may or may not grant the Dahlberg challenge. So if the Dahlberg challenge is against you, you don't want the judge to grant that. That kicks you off the case. A complex Dahlberg challenge goes on for multiple days. And I've seen this myself in person in a court case I was working on. The Dahlberg challenge was not against me, but there was another person involved in the case, another expert witness. That person is trying to be kicked off the case. And I went to the courtroom, I think a couple of days in a row, and was told to go home because this Dahlberg challenge was going on, for several days. Okay. Now, under Dahlberg, the Supreme Court, with those two cases, came up with these following factors. Make sure you know these. First, whether the theory or technique in question can be and has been tested. So you just can't make up your own theory or techniques. They have to be acceptable, right? Second one sort of relates to that. Whether the theory or technique has been subjected to peer review and publication. Can you find other sources, peer review, publications that say, yes, the technique you're using to compute damages is acceptable in the professional community? Then the theory or technique's known or potential error rate, that gets into really scientific technology, witness and so forth. Fourth, whether the theory or technique has attracted widespread acceptance within the relative community. Sort of touched on that. Is it widely accepted? And the last one, existence and maintenance of standards controlling its operations. So, again, these things must be present in your work and be accepted. Good techniques and standards and so forth to be acceptable. Go to the next one. Nothing here. Down here, to help avoid legal challenges, I'll let you read these 10 yourself. The first couple, you need to know the relevant professional standards. You need to apply them. Know the literature, and just keep going. This will help you if you follow these sort of like little rules here, tips, that will help you survive a Dahlberg challenge because you want your work to be professional and be accepted. Next page, nothing here. Again, read these pages I'm skipping over. After you go through, sometimes it feels like tons of paperwork. You're reading depositions, looking at, like I said earlier, accounting records, tax returns. You're gathering data from other sources. And you come up with, as an accountant, usually an opinion as to the amount of damages for the party you're working for. You put that into a report, an expert report. It must be written, must be signed. So what goes in the expert report? So you can see here, it must contain a complete statement of all opinions to be expressed. That's your opinion, and the basis and reasons for those opinions. The basis is a lot of the work that you'll put in the report as like exhibits in the back. The data or other information the accountant considered informing the opinions. What data did you look at? What records did you look at? Any exhibits to be used as a summary of support for the opinions. Again, prepare exhibits that are clear and show your work, how you came up with your opinion. Also, your qualifications. List all your publications that you've been involved in the past 10 years. You have to put this compensation, your compensation, in that report. You think, well, that was in the engagement letter with the attorney. It also goes in this report. You have to tell everyone, this is public information, how much you're being paid to work on this case. And the last one, a list of any cases in which the accountant has testified as an expert at trial or by deposition within the previous or preceding 4 years. This must go in the report. And then opinion reports, that's usually what you're going to be doing. You're saying, in my opinion, the amount of the damages are whatever, such and such, right? And you'll have a lot of information in the report to back that up. That's your opinion. Here's the organization. It starts off with the name and docket number of the case, your qualifications, information. These are documents you considered informing the opinions, a list of other cases which you testified, talked about that, compensation, and more opinions. Okay, let's see what else. You don't want to be side taking. Working papers. This is very important here. As an expert witness, any of your working papers can be subpoenaed and usually given to the other side. So that's why you always be careful what you write down. Any drafts and so forth, they can be subpoenaed. So it's not just your report the other side can see. They could subpoena and get a hold of your working papers. Okay. Exhibits. A lot of times exhibits are very good in trial. But remember, you're working for an attorney. So you contact that attorney and say, what exhibits would you like for me to show in the courtroom? It might help you explain a very complicated accounting rule or technique or whatever. If you can put that in some kind of chart, a screen that can show the judge or jury what you're talking about and base your opinion on that, that would help you. But you make sure you clear that with the attorney you're working for. This is interesting. Studies show that the average person retains as much as 87% of information presented visually, and as little as 10% of information given orally. So if they can see something, that's a picture in their mind. 87% retention rate. Just talking, just 10% retention. So sometimes these are very, very good. Now, early in the case, after you've done a lot of the work and issued your report, you might be called in on a deposition. This is where the other side brings you into usually a conference room in one of the attorney's offices, and they're going to put you under oath, and you have to explain, your opinion, the work you did. You'll be answering the other, and it's the other side, the other attorney on the other side of the case is going to be asking those questions. They're using this to see what kind of witness would this person be on the witness stand. What kind of work did they do? Can I punch holes in their work right now? Do they look like they'll be a good witness or not? They're using this to get you nailed down in answers. They can use your deposition answers in trial later on if they find some kind of conflict of what you wrote and what you said. But this is under oath. It's very important. Sometimes there's a transcript, there's audio or a video. Okay. And expert witnesses, when you are an expert, you could be asked about any of this, either in deposition or at trial. The scope of your assignment, your current employment, education, licenses, work experience, and the list goes on. They might ask you all of these in the deposition or, if they're not deposition, at trial. Tips on giving depositions. A whole list of them here. I'll let you read most of these yourself. The first one, don't bring notes. If you bring notes, diagrams, books, the other side can ask to look at those. Always tell the truth, but answer only the question asked. Don't volunteer information. Ask the question, and let's go down to here also. Never answer a question you don't understand. When the other side asks you the question, make sure you understand it. If you don't understand, ask the attorney to rephrase it, repeat it, or whatever. Answer only that question. Answer truthfully. You must do that. And the others down here, read through these. This is sort of really, in a way, sort of amusing, but it's true. So here are the 7 answers to most deposition questions. Yes, no, green. Talk about that in a second. I don't know. I don't remember. I don't understand. The question, I need a break. Okay. Green. Why is green here? Look at my green highlight. If you're asked, what is the color of your car? And you have a green car, you should say, green. Stop there. If you say something like, it's an old green Ford, you just volunteered 2 bits of information that were not asked. They wanted to know the color. You just told them it was old and it was a Ford. That's too much information in that answer. What color is your car? Green. Stop there. Okay. So answer the question truthfully, but succinctly. What is the exact question? Do you understand it? Give an exact answer. No more, no less. Now, at trial now, this is past the deposition. At trial, there is a direct examination. That's where the attorney you're working for is asking you questions to make you look good. You're explaining your material. They're asking you about your background probably to build you up. That's the direct examination. The cross-examination, the other attorney comes in and asks questions. They try to cut you down. They're trying to make it look like your opinion is not worth what you say it is, your numbers are wrong, or whatever, trying to make you look bad in front of the judge or jury. If that happens, your attorney might come back in. The third point here, the redirect, is now your attorney steps in, asks you questions to clear things up, and try to build you back up in front of the judge and or jury. Let's see, testimony on the stand. Following tips. I think we have several pages of tips here, so I'm not going to start into these. But again, don't be late. But read through these. If you're on the witness stand, look at all these pointers. Here, goes to the next page, I believe. All these. Okay. And just pull one out of here. Don't try to answer a question you don't understand. Okay. If you don't understand it, or if it's ambiguous or whatever, ask for them to repeat it or rephrase it. Okay. So good tips there. And again, during the cross-examination, the other attorney is going to try to cut you down. They might try to look like you were insufficiently prepared and try to cast doubt on your testimony. Whole list of reasons here that they'll go after you and try to make you look bad, in other words. And let me see, I think another point. I thought there was a point here on we talked about that earlier, excuse me. Now, one thing you need to be aware of is, as an expert witness, if somehow you don't, or the client you're working for, the attorney you're working for, and the attorney's client, the plaintiff or defendant, feels like you did not do an adequate job, did not follow standards or whatever, they might come back and sue you. I mean, the person you're working for, the attorney you're working for, might later on come back and sue you. That's what this is talking about. In the past, there was expert witness immunity, but not so much anymore. In recent years, state courts have narrowed the protection afforded expert witnesses by ruling that friendly expert witnesses can be sued for negligently preparing their opinions or evidence. This says that the attorney you work for, like I just said, can come back and sue you. That's the friendly. You're the friendly expert to that person. They can come back and sue you. This is a separate case. This is the one you were working on. They feel like the one you're working on, you did not do an adequate job. They might come back and sue you, and you don't want this to happen. They might say there's a breach of contract. They might say you were negligent. So be careful. I'll let you read through these white-collar prison sentences and fines and so forth. I'll let you read through this, the mail wire fraud, and then that's the end of the chapter. So again, go back and read the chapter in detail yourself. And as always, good luck with your studies.